This is part 3 of a 4-part series on local banking law. This video addresses how a fiscal agent or bank is selected by entities located in parishes or municipalities with populations of more than 100,000. If you missed part 1 of this series, which discusses definitions of local depositing authorities and fiscal agent, it may help to go back and watch that video first. Part 2 of this series discusses the selection of fiscal agents by entities located in parishes or municipalities with populations under 100,000, and Part 4 discusses the selection of fiscal agents by cities with populations over 150,000. So if either of those two videos are what you're actually looking for, you can go ahead and skip to those now. Entities located in whole or in part in any parish or municipality with a population of over 100,000 must follow the specific rules set out in Revised Statute 39-1214 when selecting their fiscal agent. These rules require the entity to invite bids from Louisiana banks for their services. There's no specific time limit for how long these contracts may last, but they're usually of short duration, 1 to 3 years, so as to allow the entity to choose another bank at the end of the contract if they're not satisfied with their services or if better terms might be available. The steps to bid for contracts are 1. 30 days before the prior contract expires, the entity must give written notice to each of the banks located in any parish which embraces all or a portion of the political subdivision where the entity is domiciled, setting forth its intention to select a bank as its fiscal agent. 2. The notice must specify the time for which the contract shall be made and the conditions and terms of the contract proposed. 3. The notice shall invite bids under the terms and conditions of the proposal. 4. A copy of the notice must be published in the official journal of the local entity at least 3 times. 5. The first notice must be published at least 15 days before the date selected for the selection of the bank. If, after following this process, the entity is unable to arrive at a satisfactory fiscal agency contract with a bank located in the state, it may consummate a private contract for deposits or loans or both, either within or without this state, subject to the conditions located in Revised Statute 39-1215. Good practice suggests that the entity keep evidence of its failed attempts to contract with a bank located in the state. The funds themselves must be placed in interest-bearing accounts at an interest rate of not less than 25% below the discount Treasury bill rate with regard to Treasury bills of comparable maturity. Learn more by visiting the legal FAQs at the Legislative Auditor's website at lla.la.gov. This video is for informational purposes only. It is not a substitute for legal counsel. Please consult with your attorney before making any decisions.